gadgets. Mr. Ademola Adimbola, you are for.
Can you hold this on
for the first defendant?
The first defendant, he wants use of surface, so.
And there's one Chris Okorondu.
My lord, Chris Okorondu is the plaintiff.
So he needs to mute his gadget because
I've sent him a message to do that. We are now in the same location.
Mr. Fatai of Fortune Technologies, can you mute Mr. Chris Okorondu? There are so many other people that have not muted their gadgets, which is disrupting the proceedings. Madam Sani, registrar, please, if you notice any noise during the judgment.
This guy judgment. I say fine judgment at the not Zoom. No, not Zoom. Everybody can log in. Yeah, the judgment. So what that?
I do not know what.
So do my their house. They are the more. She not be come. They don't transfer, so she can. They give the judgment via Zoom.
Indeed, Aneke. Station registrar, get in touch with Mr. Fatai that there are so many people who that are. Okay, thank you. Judgment.
Maybe she get that case. No, you can't speak. They'll mute all the thing. How does she get this? Everything. One they don't
plaintiff, judgment. The plaintiff commenced this suit by an originating summons filed on 14th July 2022. The plaintiff, one Dr. Okorondu Nwachukwu, seek the determination of two questions. The summons is issued against two defendants, namely Labour Party LP, first defendant, and the Independent National Electoral Commission, INEC, second defendant. The plaintiff subscribed the following questions for determination. One, when in the light of the provision of section 31 and 33 of the Electoral Act 2022, the second defendant can act upon the first defendant's letter dated 8th day of July 2022, written without the knowledge and consent of the plaintiff, informing the second defendant of the purported withdrawal of the plaintiff as a candidate sponsored by the second defendant to contest the Imo North senatorial election in the forthcoming 2023 general election. Two, whether in the light of the plaintiff's letter dated 13th July 2022 to the second defendant and the provision of section 33 of the Electoral Act 2022, the defendant can change or substitute the name of the plaintiff with another candidate as the candidate sponsored by the first defendant to contest the Imo North senatorial election in the forthcoming 2023 general election without the withdrawal and consent of the plaintiff. Relief sought. If the answers to the above questions are in the affirmative, the plaintiff seeks the following reliefs.
Okay.
Senatorial election in the forthcoming 2023 general election, having emerged from the first defendant primary election conducted on the 9th day of June 2022, which was monitored by the second defendant. 2, a declaration that the primary election conducted by the first defendant on the 8th of July 2022 for Imo North Senatorial Zone was conducted in accordance with the provision of Section 84 of the Electoral Act 2022. 3, a declaration that the first defendant's letter dated 8th July 2022, written to the second defendant, informing the second defendant of the withdrawal of the plaintiff as the candidate sponsored by the first defendant to contest the Imo North senatorial election in the forthcoming 2023 general election without the consent and knowledge of the plaintiff is null and void. 4, a declaration that in the light of Section 31 of the Electoral Act 2022, it is only the plaintiff that can validly withdraw as a candidate sponsored by the first defendant to contest the Imo North senatorial election in the forthcoming 2023 general election. 5, a declaration that in the light of Section 33 of the Electoral Act 2022, the defendants cannot change or substitute the name of the plaintiff as the candidate sponsored by the first defendant to contest the Imo North senatorial election in the forthcoming 2023 general election without the knowledge of and consent of the plaintiff. 6, an order of perpetual injunction restraining the first defendant from forwarding the name of any other person apart from the plaintiff as the validly sponsored candidate of the first defendant to contest the Imo North senatorial election in the forthcoming 2023 general election, having emerged as the winner of the first defendant's primary election monitored by the second defendant on the 9th day of June 2022. 7, an order of perpetual injunction restraining the second defendant from recognizing any other person apart from the plaintiff as the validly sponsored candidate by the first defendant to contest the Imo North senatorial election in the forthcoming 2023 general election, having emerged as the winner of the first defendant primary election monitored by the second defendant on the 9th day of June 2022. An order 8. An order of this Honorable Court directing the second defendant to recognize the plaintiff as a lawful candidate validly sponsored by the first defendant having emerged as the winner of the first defendant primary election monitored by the second defendant on the 9th day of June 2022. 9, an order of this Honorable Court directing the second defendant to discountenance the result of any other primary election conducted by the first defendant after the primary election monitored by the second defendant on the 9th day of June 2022 for the Imo North senatorial zone. In support of the originating summons is an affidavit of 14 paragraphs deposed to by the plaintiff himself. And next to the plaintiff's affidavits are 5 exhibits marked Exhibit A to E. 1, Exhibit A is the first defendant's letter dated 25th May 2022, informing the second defendant of dates, times, and venues of his primary election in Imo State. 2, B is another letter dated 26th of May 2022, informing the second defendant of the primaries of the first defendant in Imo State will take place on 2022, showing the date, time, and venue of the primaries.
Which is this one?
Exhibit C, the report of the election and party monitoring department of the second defendant, showing that the plaintiff is the winner of the first defendant primary election for Imo North Central Zone of Imo State, which election was monitored by officials of the second defendant, namely Sir Barrister Victor Nokebia, Dr. Ijoma Onyejoba, Mr. Ugochukwu Mboma, Mr. Iro Abali Mba, and Nicholas Elenwule. Exhibit D is a letter dated 8th July 2022, written by the first defendant to the second defendant, informing the second defendant of the plaintiff's withdrawal as the candidate of the first defendant and informing second defendant of the first defendant's intention to conduct another primary election. 5, Exhibit E1 and Exhibit E2 is the plaintiff's letter dated 13th June 2022 to the defendants to inform the second defendant that he did not withdraw as the candidate of the first defendant for Imo North Senatorial Zone. Counsel, are you still there? Can you hear me?
I can hear you, my lord. As the plaintiff counsel, my lord.
Okay. On being served with the originating summons on the defendants, the first defendant joined issues with the plaintiff by filing a notice of preliminary objection dated 7th day of September 2022 with a 5-paragraph affidavit in support of the notice of preliminary objection, deposed to by one Isiaka Popola, a litigation clerk in the law firm of Afe Babanola & Co., counsel to the first defendant in this suit with one exhibit. Exhibit 1 is the defendant's Constitution 2019 as amended. The deponent stated thus: 1, the plaintiff is a member of the first defendant. 2, the subject matter of this suit borders on a dispute relating to the candidature of the first defendant for the seat of Imo North Senatorial Zone. 3, the plaintiff did not fulfill the condition precedent laid down in the first defendant's Constitution before commencing this suit. 4, the plaintiff is bound by the first defendant's Constitution 2019. And 5, the plaintiff's suit was not commenced by due process of law. Counsel to the first defendant, Kehinde Ogunwumiju SAN, in his written address in support of the notice of preliminary objection, formulated one issue for determination, viz. Whether or not this honorable court has the jurisdiction to entertain the suit. Dana Silk submitted that the sole issue for determination of this preliminary objection ought to be resolved in the negative, since the plaintiff's suit is incompetent for failure to fulfill a requisite condition precedent, and that this suit was not commenced by due process of law. Lanat SAN submitted that it is rudimentary law that before any action is initiated in a court of law, all the conditions precedent to the institution of an action must have been fulfilled. And it is only upon the fulfillment of a condition precedent that an action can be said to be properly brought. And that where there's a failure to fulfill a condition precedent to the filing of a suit, the court lacks the jurisdictional competence to entertain such a suit. Counsel submitted that it has been held in a plethora of cases that the constitution of political parties is made by the members of such parties to regulate the conduct of their affairs. And once made and agreed upon, the constitution becomes binding on its members. And that the plaintiff in this case has failed to fulfill the condition precedent laid down by the first defendant in its constitution. The said condition precedent is that the members of the political party shall exhaust all avenues for settlement of or redress within the party. The said constitution goes further to state that the member of the first defendant will not approach the court without following the laid down procedure under the first defendant's constitution, as cited Article 19(1)(d) 6 and 7 of the first defendant Constitution 2019. Counsel contended that this suit ought to be struck out for failure of the plaintiff to exhaust the internal administrative remedies provided in the first defendant's Constitution. Leonard SAN argued further that this suit was not commenced by due process of law, which is two-pronged. First, The first defendant is contending that the affidavit and exhibits in support of the plaintiff's originating summons show that the plaintiff is surreptitiously seeking to establish an allegation of forgery by affidavit evidence. Secondly, it is the first defendant's position that there are serious disputes of facts in this suit, and same cannot be resolved by way of originating summons procedure. That a civil case which requires proof beyond reasonable doubt cannot and ought not to be resolved via affidavit evidence, that such a case requires the calling of oral evidence whereby witnesses will be called upon to establish the allegations made by the plaintiff in the suit. Such a case cannot, by any stretch of the imagination, be established by the originating summons procedure, but by a writ of summons procedure, considering that facts will be in serious dispute. Leonard Seal concluded that this suit, having been wrongly commenced by originating summons, is incompetent. And this honorable court does not have the jurisdictional competence to hear and determine, saying also that this suit is premature and ought to be struck out by this honorable court. In reaction to the first defendant's preliminary objection, the plaintiff on 12 September 2022 filed a 5-paragraph counter affidavit and a written address in opposition. The counter affidavit is deposed to by one Peter Iwano, a litigation clerk in the firm of E.A. Adedeji and Co. with 3 exhibits, being one exhibit A is the second defendant's report on the results of the primary election conducted by the first defendant for the Imo North Senatorial Zone, which was won by the plaintiff and monitored by the second defendant. Exhibit B is the submission of names form signed by the chairman and secretary of the first defendant, submitting the name of the plaintiff to the second defendant as the winner of the primary election for Imo North Senatorial Zone. Exhibit C is a letter written by the first defendant to the second defendant, informing the second defendant that the plaintiff has withdrawn his candidature without consulting the plaintiff. Exhibit D is the plaintiff's letter to the second defendant, informing the second defendant that he has not withdrawn his candidature. Counsel to the plaintiff, E.A. Adedeji Esquire, in his written address in opposition to the first defendant's notice of preliminary objection, submitted that the issues that arises for determination of this honorable court are 2. 1, whether having regards to the provision of section 84 sub 14 of Electoral Act 2022 and decisions of the appellate courts, the exploration/exhaustion of internal mechanisms for dispute resolution contained in the first defendant's constitution is a condition precedent for an aggrieved member of the first defendant to institute an action in court. 2, excuse me, whether a party who has not disputed facts deposed to in an affidavit can complain that facts contained in an affidavit are likely to be hostile. Leonard Counsel submitted that the plaintiff filed this case seeking interpretations of sections 31 and 33 of the Electoral Act 2022 in order to determine whether, upon the submission of the plaintiff's name by the first defendant to the second defendant, the defendants can substitute the plaintiff's name as the candidate of the first defendant for Imo Senatorial Zone election when he is not dead and he has not withdrawn his candidature. Counsel argued that in order to determine whether the facts of this case is an internal dispute between the first defendant and the plaintiff, that will require the plaintiff to revert to and exhaust internal mechanism of dispute resolution provided by the constitution of the first defendant before instituting this case. This court will have to examine the plaintiff's course of action, and that by section 33 of the provisions of the Electoral Act 2022, the question of withdrawals and or substitution of candidates is no longer the internal affairs of political parties simpliciter, meaning that once a candidate emerges from a primary election of a political party and his or her name has been submitted to the second defendant, the political party cannot arbitrarily withdraw or substitute that candidate. And the operative word used is shall, which word underscores the mandatory nature of the provision. And that again, beyond the fact that withdrawal / submission, substitution of candidates whose names has been submitted to the second defendant is no longer the internal affairs of a political party. The section also stipulates time frame within which a fresh primary election will be conducted in the event of withdrawal or death of a candidate already validly nominated. Learned Counsel submitted that the rule of equity is clear to the effect that he who must seek equity must show that his hands are clean, that the first defendant cannot complain that the plaintiff acted in breach of his constitution by instituting this action without exploring and indeed exhausting internal conflict resolution mechanism, because the first defendant itself acted traitorously, arbitrarily, and in breach of his own constitution by making false claims to the second defendant in order to rob the plaintiff of his candidacy. And that having written to the second defendant that the plaintiff had withdrawn his candidacy, it was no longer within the powers of the internal organs of the first defendant to determine whether the plaintiff had validly withdrawn his candidacy or not. So it will be futile to expect that the plaintiff to submit to internal resolution over a matter Council, are you still there?
I'm here, my lord.
Okay. That it is only the second defendant and the court of law that can make that determination. So it will be futile to expect the plaintiff to submit to internal resolution over a matter the first defendant had no power to resolve, having requested the second defendant to substitute the plaintiff. Counsel submitted that the gravamen of the first defendant's preliminary objection is that the plaintiff's suit is incompetent for failure to fulfill requisite condition precedent, and that the plaintiff's suit was not commenced by due process of law, that yet the first defendant failed to refer this honorable court to the provision of the first defendant's constitution, which stipulates the condition precedents to be fulfilled by the plaintiff to challenge the unlawful attempt by the first defendant to substitute his name. Therefore, counsel submitted that there's no provision of the first defendant's constitution which deal with matters or dispute arising from substitution of names submitted to the second defendant, and that substitution of names of candidates are only provided for in the Electoral Acts, and this honorable court has exclusive jurisdiction to adjudicate over dispute arising from the provisions of the Electoral Act, and cited Section 84(14) of the Electoral Act 2022. Learned Counsel contended that on the first limb of the first defendant argument that the plaintiff's affidavit never mentioned the word forgery. However, if the first defendant, after a soul-searching exercise, comes to the conclusion that its letter of 8th July 2022, wherein it alleged that the plaintiff wrote a letter.
Did you see what I dropped on your office?
his candidacy and deposed to an affidavit to that effect, orders on forgery, then so be it.
I dropped waterproof, black waterproof in your office.
And that the contention of the plaintiff is that the first defendant has not joined issues with the plaintiff in this suit, as all the facts deposed by the plaintiff have not been denied, disputed, contradicted, or challenged by any of the first defendant, and that it is incumbent on the first defendant to join issues with the plaintiff and produce in court the letter of withdrawal and affidavit allegedly posed to by the plaintiff.
I said it to somebody to tweak it. I said, listen and get back to me when I was done with.
To do so. The second defendant, who also purportedly received the alleged plaintiff's letter of withdrawal and affidavit, have also not produced them in court. That therefore, the first defendant, who has not joined issues with the plaintiff or denied the facts deposed, to be arguing that the case should be struck out for having not been commenced through due process of law. Legal counsel contended that any conflict or dispute as to facts in the affidavits of parties before a court of law can only be gleaned from the affidavits of both parties, and that the submission of the first defendant that the plaintiff ought to have commenced this suit by writ of summons is against the provisions of the Federal High Court Pre-Election Practice Direction 2022, which specifically stipulates that the only mode of commencing a pre-election matter is by an originating summons. Also, in the absence of any counter affidavit to the plaintiff's suit cannot be said to be contentious. Counsel concluded by submitting that the case of the plaintiff is challenging the powers of the second defendant to substitute his name when he's not dead and he has not withdrawn his candidature, and that there's no provision in the constitution of the first defendant stipulating the procedures to be followed by the plaintiff in filing this suit. Counsel urged the Honorable Court to dismiss the first defendant notice of preliminary objection and to resolve the issue for determination distilled above in the negative and in favor of the plaintiff, and to accordingly dismiss the first defendant's applicant's preliminary objection for lacking in merit. The first defendants filed a reply on points of law to the plaintiff's written address in opposition to the notice of preliminary objection. Leonard Silk Kehinde Ogunwumijo, in his written address, contended that the first defendant position has nothing to do with the internal affairs of a political party or the right of the plaintiff to approach this Honorable Court to ventilate his grievances. Rather, the first defendant's position is that the condition precedent embedded in the first defendant's constitution must be complied with before the plaintiff can approach this Honorable Court. That, in essence, the fact that the plaintiff has the right to approach the court pursuant to the relevant provisions of the Electoral Act 2022 does not jettison the need for him to comply with the provisions of the first defendant's constitution, which is bound to obey. Therefore, the arguments made by the plaintiff in respect of withdrawal / substitution are misconceived and ought to be discountenanced by this Honorable Court. That it is the first defendant's further submission that the plaintiff has woefully failed in his attempt to confuse this Honorable Court, that the first defendant's argument in its notice of preliminary objection relates to an issue arising from the primary election of the first defendant. That the first defendant's argument in its notice of preliminary objection order on
give us a Oscar, make it carry go, then column.
The first defendant's argument in this notice of preliminary objection borders on the nomination of the first defendant's candidate for the seat of senator representing Imo North Senatorial Zone and has nothing to do with the primary election. However, it is the first defendant's submission that the plaintiff, having failed to even approach the neck of the first defendant as regards his alleged substitution, does not have the requisite virus to activate the jurisdiction of this honorable court to determine the suit. To fulfill a condition, a council. Leonard Council on this platform. Can you still hear me?
Yes, we can hear you, my lord. It was muted for some time.
Thank you. Oh, I see. I was not aware. Once again, okay. The fact that there's an alleged breach of the provisions of the Electoral Act, SUPRA does not dispense with the need for the plaintiff to fulfill a condition precedent, and the plaintiff never controverted the fact that he has not complied with the condition precedent as required by the first defendant's constitution. Rather, he has only tried to justify his actions of not complying with the condition precedent. It is tried law that uncontroverted fact is deemed admitted, and also the plaintiff argument that the first defendant must join issues with the plaintiff before it can be heard to argue that the suit be struck out for having not been commenced by due process of law. Now, the first defendant submits that this argument does not hold water in line with the several judicial authorities cited, and that the only process which the court looks at to determine whether it can adjudicate on the matter is that of the plaintiff alone. It is therefore the first defendant's further submission that the fact that it has not joined issues with the plaintiff is of no moment, and that in the instance suit before this honorable court, the originating process is the originating summons, affidavit in support with the attached exhibits and the written address, and ask the court to find that an in-depth analysis of the plaintiff's originating process and its accompanying affidavits and exhibits will reveal that this suit is extremely contentious, and that the first defendant position that once an allegation of forgery is made, it cannot be determined by the originating summons procedure. Therefore, the non-filing of the first defendant process is irrelevant to the determination of the issues before this honorable court. Meanwhile, the second defendant never put in an appearance despite the proof of service of being served with the originating summons and all other processes. Now, this honorable court will utilize the non-issue articulated by Kehinde Ogunwumi Jose and counsel to the first defendant, which is whether or not this honorable court has the jurisdiction to entertain the suit. Jurisdiction is generally a crucial and radical question. A challenge to a court's jurisdiction must necessarily be determined first. If a court lacks jurisdiction to determine a matter, then all proceedings undertaken by the court becomes a nullity, however well conducted. That makes jurisdiction a threshold matter. See University of Ilorin and others versus Oluwadare 2009, All Federation Weekly Law Report. The Court of Appeal, Panueze JCA, as he then was, opined that jurisdiction is to a court what a gate is or door is to a house. That is why the question of a court's jurisdiction is called a threshold issue. It is at the threshold, that is at the court. A prospective litigant must satisfy the gatekeeper that it has a genuine cause to be allowed ingress. Where he fails to convince the gatekeeper, he'll be denied access to the inns of the temple. The gatekeeper, as vigilant as is always, will readily intercept and query all persons who intrude into his domain. To be able to ventilate a grievance, a prospective litigant has to ensure that he addresses his complaint to the competent court. That is so, for an incompetent court will have no jurisdiction to attend to his entreaty. The apex court in the case of Nigeria Deposit Insurance Corporation versus Central Bank of Nigeria 2002 SC held thus, jurisdiction is the very basis in which any tribunal tries a case. It is a lifeline of all trials. A trial without jurisdiction is a nullity. The importance of jurisdiction is the reason why it can be raised at any stage of a case, be it at the trial, on appeal to the Court of Appeal, or to this court, a fortiori, a court can so moto raise it. The law is settled on how to determine the jurisdiction of the court. See Gabriel Madukolu and others versus Johnson Ikemdilim, 1962, to All Nigerian Law Report 587 at 592. 595. A plethora of cases have re-established that jurisdiction has impact on competency of the court and is determined on the following principles. One, it is properly constituted with respect to the number and qualification of its members. Two, it has jurisdiction over the subject matter. Three, the action is initiated by due process of law. And four, any condition precedent to the exercise of its jurisdiction has been fulfilled. All the combined effects of the second and the combined effect of the second or third conditions mentioned above is that the court's jurisdiction abates where the plaintiff in his claim fails to disclose a cause of action. It is now indeed settled law that a cause of action is the entire factual situation, the existence of which entitles one person to obtain from a court a remedy against another person. It is this factual scenario that forms the basis of invoking the jurisdiction of court in a suit. See Ejikwara State versus Olawole 1993, No Rika versus Ononeze Madu and others 2019, and Adeyemi versus Opeyori, etc. A court must have both jurisdiction and competence to be properly seized of a cause or matter. Jurisdiction in that sense means legal capacity, power or authority vested in it by the Constitution to statute creating the offense. See PDP versus Okorocha, SC 2012. This court being a creator of statute and it is from thence it draws its jurisdiction. The law has since been settled that courts have no jurisdiction to interfere in the internal affairs of a political party. See Onoha versus Okafo 1983, 14 NSCC, and Hatu versus Turaki 2003, 15 NWLR, PDP versus Silva 2012, 3 NWLR, Ufomba versus INEC 2017, PDP versus Ogundipe 2018, etc. However, this non-interference will not avail a party where it fails to follow its constitution, the Electoral Act, and the party guidelines, meaning that the law has now crystallized that the court will unhesitatingly intervene where the political party violates its own rules, the Electoral Acts, or acts arbitrarily. See Chief Ogulebo versus PDP 2021, LPELR, APC versus Lere 2020, Agi versus PDP 2017, Ugu versus PDP 2015, Eminike versus PDP 2012, and Anyao versus Oguniwe 2014, NWLR. In Jev versus Ayotem 2012, LPELR, the Court of Appeal stated thus: the position of the law hitherto to the enactment of Section 87(9) of the Electoral Acts as amended 2022 is that the issue of nomination of candidates is an internal affair of the political party to be resolved by them. Since the amendment to the Constitution/Electoral Act, the Federal High Court is vested with express jurisdiction to adjudicate on grievances arising from political party primaries, as long as the subject matter is on non-compliance with party guidelines or the Electoral Act. The jurisdiction of the court in pre-election matters is construed narrowly, and the court must ensure it acts within its jurisdiction for that purpose. Pre-election matters are basically matters that come up before the general elections. The superior courts have held that matters such as the nomination or substitution of candidates of the, for an election are pre-election matters which come within the purview of the Federal High Court. See Obot versus Etim and others 2007 LPELR, where the Court of Appeal held, I quote, moreover, the issue of candidature of a person as between himself and his political party is a pre-election matter or issue within the jurisdiction of the Federal High Court. This honorable court, in resolving the issue, starting with the preliminary point, in arguing the preliminary point, the first defendant contended that the plaintiff's suit is incompetent by reason of his neglect or failure to join one Mr. Ifeanyi Godwin Ararume to the suit, alleging that the said Mr. Ararume is a necessary party to this suit, having been nominated by the first defendant and his name submitted to the second defendant. The first defendant premised its contention that Mr. Ararume is a necessary party to this suit on the provision of Rule 3 of the Federal High Court of Nigeria, Pre-Election Practice Direction 2022. The plaintiff, on the contrary, contended that the first defendant missed the point, misconceived and misapprehended the meat of the case, and that the plaintiff's contention that the said Mr. Ararume is not a necessary party to this suit, relying on the provision of Rule 3 of the Federal High Court of Nigeria, Pre-Election Practice Direction 2022, the provision of which the first defendant has predicated his preliminary point, is reproduced here. Rule 3, I quote, a party challenging the conduct or outcome of a primary election shall join as a respondent in the suit the person who emerged winner of the said election or whose name was forwarded by his party to Independent National Electoral Commission, INEC. Now, the wording of the provision of Rule 3 quoted above is very plain, clear, and unambiguous. The intention of the maker of the rule is also crystal clear. The key phrase used in Rule 3 is a party challenging the conduct or outcome of a primary election. The key question to be asked then is this suit as constituted challenging the conduct or outcome of a primary election as envisaged by Rule 3 of the Federal High Court of Nigeria Pre-Election Practice Direction 2022? This court ventures a resounding answer as a capital no, based on the affidavit of the parties before the court. The plaintiff at paragraph 12T of his further and better affidavit stated that when he contested the primary election that produced him as the first defendant's candidate for the Imo North Senatorial Zone for the 2023 general election and his name forwarded to the second defendant, the said Mr. Ararumi was not a member of the first defendant, that Mr. Ararumi was a member of the People's Democratic Party, PDP, where he contested the Imo North Senatorial Zone primary election of that party for the 2023 general election, but lost the election, and that none of the aspirants who contested the Imo North Senatorial Zone primary election of the first defendant with the plaintiff challenged, disputed, or protested the plaintiff's emergence and declaration as the candidature of the first defendant. The first defendant only submitted the name of the plaintiff to the second defendant as the senatorial candidate for Imo North Senatorial Zone because there was no challenge, disputation, or litigation regarding his candidature. I so hold. The first defendant in this suit has not denied that the plaintiff contested and won the Imo North Senatorial Zone and that it forwarded his name to the second defendant as its candidate for the position. Therefore, the plaintiff's suit has nothing to do with the conduct of or outcome of a primary election as envisaged by Rule 3 of the Federal High Court of Nigeria Pre-Election Practice Direction 2022 and as contended by the first defendant. I so hold. The question is, since this present suit is not one challenging the conduct or outcome of a primary election, what then is the plaintiff's challenging through this suit? The answer is that the plaintiff is contending that after he has been validly and lawfully nominated as the candidate of the first defendant and his name forwarded to the second defendant, the first defendant wrote a letter dated 8th July 2022, which is Exhibit D, alleging that it received a letter of voluntary withdrawal from the plaintiff, as well as an affidavit in support of the alleged letter, to which the plaintiff denies. The purported letter of voluntary withdrawal has been produced in this case as Exhibit G. This honorable court also holds that going by the affidavit evidence of all the parties in this case, what is not in contention is that a primary election held, which produced the plaintiff as the eventual winner. And again, what has not been contested for is that in the election, it was not contested for by the state one, Mr. Ifeanyi Godwin Ararumi, when whom the plaintiff contains was not a member of the first defendant when the plaintiff contested and won the ticket for the Imo North Senatorial Zone, and his name is duly submitted to the second defendant. Consequently, this honorable court, going by the analysis, holds that the plaintiff is the candidate of the first defendant for Imo North Senatorial Zone. The plaintiff, having not died or validly withdrawn the first defendant, cannot legally and lawfully organize another primary election to substitute the plaintiff. Consequently, no occasion or situation arose for the first defendant to conduct another primary election for the emergence of another candidate. Therefore, this honorable court holds that plaintiff is the validly nominated candidate of the first defendant for Imo North Senatorial Zone. This court was based on the earlier analysis conducted that the said Ifeanyi Godwin Ararumi is not a necessary party in a suit where the plaintiff is challenging the validity or otherwise of his purported withdrawal in an election that the said Mr. Ifeanyi Ararumi was not an aspirant, nor a contestant. Now, having determined this preliminary issue, the next issue raised by the learned spoke to the first defendant, who reiterated that their position has nothing to do with the internal affairs of a political party or the right of the plaintiff to approach this honorable court to ventilate his grievances. Rather, the first defendant position is that the condition precedent embedded in the first defendant constitution must be complied with before the plaintiff can approach this honorable court. That in essence, the fact that the plaintiff has a right to approach this court pursuant to the relevant provisions of the Electoral Act 2022 does not jettison the need for him to comply with the provisions of the first defendant's constitution, which is bound to obey. Therefore, the arguments made by the plaintiff in respect of withdrawal/substitution are misconceived and ought to be discountenanced by this honorable court. That is the first defendant further submission that the plaintiff has woefully failed in his attempt to confuse this honorable court. That the first defendant's argument in its notice of preliminary objection relates to an issue arising from the primary election of the first defendant. That the first defendant argument in its notice of preliminary objections border on the nomination of the first defendant candidate for the seat of senator representing Imo North Senatorial Zone and has nothing to do with the primary election. However, it is the first defendant's submission that the plaintiff haven't failed to even approach the neck of the first defendant as regards his alleged substitution does not have the requisite virus to activate the jurisdiction of this honorable court to determine this suit. While the plaintiff counsel argued that the first defendant cannot complain that the plaintiff acted in breach of his constitution by instituting this action without exploring and indeed exhausting internal conflict resolution mechanism, because the first defendant itself acted treacherously, arbitrarily, and in breach of its own constitution by making false claims to the second defendant in order to rob the plaintiff of his candidacy, and that having written to the second defendant that the plaintiff had withdrawn his candidacy, it was no longer within the powers of the internal organs of the first defendant to determine whether the plaintiff had validly withdrawn his candidacy or not. That it is only the second defendant and this court and the court of law that can make that determination. So it will be futile to expect the plaintiff to submit to internal resolution of over a matter the first defendant had no power to resolve, having requested the second defendant to substitute the plaintiff. The plaintiff stated that the real counsel.
Yes, my lord.
Okay, are you still there?
Yes, my lord. We are here.
Okay.
I'm here, my lord.
Oh, I see. Okay, thank you, counsel. The plaintiff stated that the real issue in contention in this suit emanated from Exhibit D attached to his affidavit in support of the originating summons written by the first defendant to the second defendant, alleging that the plaintiff had voluntarily withdrawn his candidacy as the senatorial candidate of the first defendant for the Imo North senatorial seat in the 2023 general elections via a purported letter of voluntary withdrawal and an affidavit in support submitted to the first defendant. That when the plaintiff got information regarding the conduct of the first defendant and the facts of Exhibit D, he quickly wrote a letter dated 13th July 2022 Exhibit E to the second defendant, disclaiming any purported letter of withdrawal and affidavit in support thereof allegedly submitted by him to the first defendant purporting to withdraw his candidacy. In the said Exhibit D, he reaffirmed his candidacy and desire to run for the Imo North senatorial seat in the 2023 general elections, and that when he did not receive any response from the second defendant to Exhibit E and to forestall any detrimental action to his candidacy that may be taken by the second defendant arising from the first defendant, Exhibit D, the plaintiff instituted this suit to seek the court's intervention and protection. The plaintiff deposed that at the time he instituted this suit on 14th July 2022, he had not seen or read either the alleged letter of voluntary withdrawal purportedly written by him or the alleged affidavit in support of the said letter of withdrawal, as none of the defendants availed him with a copy despite request to cite copies of the alleged documents. That the plaintiff cited a copy of the alleged letter of withdrawal purported to have been written by him for the first time on 14 September 2022, when the first defendant served his counsel its counter affidavit to motion on notice for injunction dated 14th July 2022, wherein it attached the purported letter of voluntary withdrawal as Exhibit LP1, that the first defendant who claimed that the plaintiff had submitted to it an affidavit in support of the purported Exhibit LP1, however, failed and or refused to exhibit the alleged affidavit in support of Exhibit LP1, it states he filed that a copy of the purported letter of voluntary withdrawal is attached and marked as Exhibit G. From the facts of this case, what is not in dispute is the wrangling or altercation between the plaintiff and the first defendant, which led to the institution of this suit, and to which the first defendant is contending that the plaintiff ought to resort to and exhaust the internal mechanism of dispute resolution provided by the Constitution of the first defendant before instituting this case. From examining the affidavits of the parties, this court cannot help but agree with the submission of the plaintiff counsel that the first defendant cannot complain that the plaintiff acted in breach of his constitution by instituting this action without exploring and indeed exhausting internal conflict resolution mechanisms, because the first defendant itself cannot be a party and at the same time adjudicate over its own case. The first defendant, having written to the second defendant that the plaintiff had withdrawn his candidacy, which the plaintiff denies, and having requested the second defendant to substitute the plaintiff, is the gravamen of this case. The plaintiff has a right to approach the court pursuant to the relevant provisions of the Electoral Act 2022. As such, three election scenarios are contemplated by the Electoral Act 2022 for the Federal High Court to adjudicate and determine. Consequently, this honorable court, having observed that from perusing all processes filed by the parties, especially the party guidelines and constitution, holds that there's no provision of first defendant constitution which deal with matters or disputes arising from substitution of names submitted to the second defendant, and that the substitution of names of candidates are only provided for in the Electoral Act. This honorable court has exclusive jurisdiction to adjudicate over disputes arising from the provisions of the Electoral Act, see Section 84(14) of the Electoral Act, which empowers an aspirant to apply to the Federal High Court, where the guidelines of the political party in its nomination or selection of candidates have not been complied with, as is in this case. Therefore, the contention of the defendant counsel that the condition precedent embedded in the first defendant's constitution must be complied with, as that does not jettison the need for the plaintiff to comply with the provisions of the first defendant's constitution, which is bound to obey before the plaintiff can approach this honorable court, cannot fly in the face of the facts deposed in the above paragraphs. This argument is misconceived and is discountenanced by this honorable court, that having regard to the provision of section 84 sub 14 of the Electoral Act 2022 and decisions of the appellate courts, the exploration / exhaustion of internal mechanisms for dispute resolution contained in the first defendant's constitution is not a condition precedent for an aggrieved member of the second defendant to institute an action in court, because a litigant who decides to wait for his political party to deliberately frustrate his right of action has himself to blame, as the rules of a political party do not have superior effect on the Constitution of Nigeria. Sinyako versus Dr. Umar Arro, 2013, LPELR. Sani versus PDP, 2019, LPELR. Shehuri versus Zulum, 2019, LPELR, and Gatumbua versus APC, 2019, LPELR. One of the cardinal rules of jurisprudence is that a cause of action cannot arise until all that needs to take place to complete the complaint has happened, and the aggrieved person is aware that his right has been infringed upon. See Musa versus David, 2020, 11 NWLR. Therefore, the first defendant's submission that the plaintiff haven't failed to approach the neck of the first defendant as regards his alleged substitution, and so does not have the requisite virus to activate the jurisdiction of this honorable court to determine this suit is not correct. The issue has gone further than that, as it is no longer an internal dispute between the first defendant and the plaintiff, to which is not justiciable. Rather, the interests of other parties have been involved in that an election was held, monitored by the second defendant, and a winner declared. The winner allegedly withdraws. The question is, the condition precedent for the withdrawal of candidates as envisioned by Section 33 Electoral Act 2022 being Therefore, the first defendant's argument in its notice of preliminary objection relates the issue arising from an internal dispute between the first defendant and the plaintiff will not fly. The first defendant counsel has woefully failed in his attempt to confuse this honorable court. I so hold. Hence, what was clearly revealed and is not in dispute is that the case of the plaintiff revolves around violation of the Electoral Act and the guidelines for elections issued by the first defendant, which gives the plaintiff the right to complain, culminating in this course of action, I find accordingly. Now, on the second issue to which Leonard SAN in his argument submitted, that this suit was not commenced by due process of law, which is described as two-pronged. First, the first defendant is contending that the affidavit and exhibits in support of the plaintiff's originating summons show that the plaintiff is surreptitiously seeking to establish an allegation of forgery by affidavit evidence. Secondly, it is the defendant's position, first defendant's position, that there are serious disputes of facts in this suit, and same cannot be resolved by way of originating summons procedure, that a civil case which requires proof beyond reasonable doubt cannot and ought not to be resolved via affidavit evidence, that such a case requires the calling of oral evidence, whereby witnesses will be called to establish the allegation made by the plaintiff in the suit. Such a case cannot by any stretch of the imagination be established by the originating summons procedure, but by a writ of summons procedure, considering that facts will be in serious dispute. Senior counsel contended that this suit, having been wrongly commenced by originating summons, is incompetent, and that this court does not have the jurisdictional competence to hear and determine same. And also this suit is premature and ought to be struck out by this honorable court. The plaintiff counsel in his response submitted that the first defendant has not joined issues with the plaintiff in this suit, as all the facts deposed to by the plaintiff have not been denied, disputed, contradicted, or challenged by any of the first defendant, and that it is incumbent on the first defendant to join issues with the plaintiff and produce in court the letter of withdrawal and affidavit allegedly deposed to by the plaintiff, but the first defendant has failed to do so. And that on the submission of the first defendant that the plaintiff ought to have commenced this suit by originating summons is against the provision of the Federal High Court Pre-Election Practice Direction 2022, which specifically stipulates that the only mode of commencing a pre-election matter is by an originating summons. Also, in the absence of any counter affidavit to the plaintiff's suit, the plaintiff's suit cannot be said to be contentious. This honorable court agrees with the plaintiff's counsel's submission. Now, the court having resolved the issue for determination in the negative and in favor of the plaintiff, accordingly dismissed the first defendant's applicant's preliminary objection for lacking in merit.
As the court places.
As what was clearly revealed and is not in dispute in this case of the plaintiff revolves around the violation of the Electoral Act and the guidelines for elections issued by the first defendant, which gives the plaintiff the right to complain, culminating in this cause of action. I find accordingly. Consequently, this court holds that the plaintiff's suit is initiated by due process of law, and there's no feature in it which robs this court of the requisite jurisdiction to entertain same. I so hold. This honorable court, having resolved the preliminary objection, will go on to determine the substantive matter initiated by the originating summons. Now, in resolving this imbroglio, this honorable court reproduced the case of the plaintiff as stated in the affidavit in support of the originating summons. In that, the first defendant, via a letter dated 25th May 2022, informed the second defendant of dates, times, and venues of its primary election in Imo State. Also, by another letter dated 26th day of May 2022, the first defendant informed the second defendant that the primaries of the first defendant in Imo State will take place on the 9th day of June 2022, showing the date, time, and venue of the primaries. That the plaintiff contested the state primary election conducted by the first defendant for Imo North Senatorial Zone of Imo State against Pauline Uzo and Desmond Uba, which election was held at 1 Urban Primary, Okigwe, Imo State on the 9th June 2022, to which the plaintiff emerged the winner of the primary election conducted by the first defendant, which was monitored by officials of the second defendant, namely Barrister Victor Nokebia, Dr. Ijeoma Onyejioba, Mr. Ugochukwu Mboma, Mr. Iro Abalimba, and Nicholas Elenwule. The plaintiff deposed that a few weeks after emerging as the winner, the state chairman of the first defendant, Chief Ambrose Onyekwere, invited him for a private meeting, to which the plaintiff was informed that a rich and prominent politician is willing to give the sum of 500 million naira for the plaintiff to withdraw as the validly elected candidate of the first defendant primary election for Imo North Senatorial Zone of Imo State, that the plaintiff declined the money offered and insisted that he's contesting the election in order to give credible representation to the people of Imo State, Senatorial Zone of Imo State. And to his surprise, he got wind of a letter dated 8 July 2022, written by the first defendant to the second defendant, informing the second defendant of the plaintiff's withdrawal as the candidate of the first defendant, and informing the second defendant of the first defendant's intention to conduct another primary election, and that the and that the 8th of July 2022, being a Friday, 9th and 10th of July 2022 are Saturday and Sunday respectively, while for 11th and 12th of July 2022 are public holidays. That on the 13th July 2022, the plaintiff instructed his lawyers to write a letter to the defendants to inform the second defendant that he did not withdraw as the candidate of the first defendant for Imo North Senatorial Zone. The plaintiff further deposed that he did not write any letter of withdrawal to the first defendant, and that the first defendant's letter dated 8th of July 2022 to the second defendant, informing the second defendant of his withdrawal, was written without his consent and without his consent and knowledge, that he remains the validly sponsored candidate of the first defendant, having emerged the winner of the first defendant primary election conducted for Imo North Senatorial Zone of Imo State, and that the second defendant, having published his name as the candidate sponsored by the first defendant to contest the Imo North Senatorial election in the forthcoming 2023 election, therefore, that the second defendant cannot change or substitute his name without his withdrawal as the candidate of the first defendant, and that he has not withdrawn as the candidate sponsored by the first defendant. Now, from the above stated facts in the plaintiff's affidavit, the question to ask is, therefore, that the second defendant cannot change or substitute his name without his withdrawal as a candidate of the first defendant, and that he has not withdrawn as a candidate sponsored by the first defendant. That's the affidavit evidence of the first of the plaintiff. The first defendant filed a further affidavit in support of the preliminary objection. I mean, the first defendant in receipt of the counter processes filed a further reply on points of law. Leonard Silk, in his arguments, adopted the two issues slated for determination by the plaintiff counsel and submitted that the entire action of the plaintiff hinged on the denial of the making of exhibit LP1, which makes this suit a fastidium of abuse of the process of this honorable court, and that this suit was not brought in good faith. And it is clear that the plaintiff has fabricated lies in a bid to frustrate and annoy the first defendant, that this suit ought to be dismissed in its entirety, as it is clearly an abuse of the process of this honorable court. On the whole, the court is urged to answer the two questions for determination in the affirmative and dismiss this suit for lacking in merit. The first defendant urges the court to dismiss suit in its entirety, having established that, one, the allegations of fraud/forgery are false and unsupported by evidence. Two, the first defendant has complied with all the requirements for the change/substitution of names under the Electoral Act 2022. Three, the first defendant has irreversibly acted upon the plaintiff's withdrawal. And that, in summary, the facts, according to the plaintiff case, one, that he won the primary election conducted by the first defendant to elect his candidate for the Imo North Senatorial Zone in the forthcoming general election. That two, is still the validly sponsored candidate of the first defendant. Three, that he got wind of the letter dated 8 July 2022 by the first defendant to the second defendant, informing the second defendant of his withdrawal as the candidate of the first defendant, and also informing the second defendant of the first defendant's intention to contest another primary election. Four, that he did not write any letter of withdrawal to the first defendant, and that he remains the valid candidate of the first defendant for the seat of Imo North Senatorial District. Now, the Electoral Act, by virtue of Section 31 and 33, make provision for withdrawal of nomination of a candidate and the steps to be taken by a political party. I'll reproduce the sections for the sake of clarity. Section 31.
The soup is too small. I know meat. I know meat.
Candidate withdraw his,
Why get meat and put inside there? Why would
her candidate?
from the two? The meat are dry.
A candidate may withdraw, Section 31 Electoral Act. A candidate may withdraw his or her candidature by notice in writing, signed by him and delivered personally by the candidate to the political party that nominated him for the election, and the political party shall convey such withdrawal to the commission not later than 90 days to the election. Section 33, a political party shall not be allowed to change or substitute its candidate whose name has been substituted under Section 29 of this Act, except in the case of death or withdrawal by the candidate, provided in the case of such withdrawal or death of a candidate, the political party of affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the commission for the election concerned. The combined effects of these provisions is that a person validly nominated by his party as his candidate may decide to withdraw his candidature under whatever reason he may deem fit. The procedure for a valid withdrawal is for such a candidate to write a notice, which may be a letter to the party, informing it of his withdrawal, and same letter must be signed and personally delivered by such candidate to the party, and then the party will convey the withdrawal to the Independent National Electoral Commission, that's the second defendant. It is only upon the fulfillment of this condition precedent can the party conduct a fresh primary. This was the position of Ogumbi JSC as he then was. In Uazurike and another versus Rachuku and another 2012 LPLR, it was held, the provision of section 35 of the same act also prescribes the mode of withdrawal by a candidate, which must be conveyed personally to the party whose responsibility it is to communicate such withdrawal to the commission. Excuse me. The cumulative effect is that once a party nominates a candidate under section 31 sub 1 of the Act, it has no corresponding power to withdraw his nomination except either by the candidate himself or upon his death when he ceases to exist. Also in INEC versus PDP and others 2022 LPLR, it was held that the stipulations of sections 33, 35, and 153 of the Electoral Act 2010 as amended, which was applicable at all times material to the action, are crucial. They provide, I've read it, section 33 before, I need not read it again. That the commission, subject to the provision of this act, issue regulation, that section 153, the commission, subject to the provisions of this act, issue regulations, guidelines, or manuals for the purpose of giving effect to the provisions of this act for its administration thereof. By the canons of interpretation of statutes, it is a cardinal principle that where the ordinary and plain meaning of the words used are clear and unambiguous, effect must be given to these words in their natural and ordinary meaning or literal sense without resorting to any intrinsic or external aids. In aliis verbis, in interpreting a statute, where the words are clear, plain, and unequivocal, natural, and grammatical meaning will permit, except there is need to give them any other meaning other than their ordinary, natural, and grammatical meaning will permit, except where it will lead to absurdity. See Adetayo versus Ademola, 2010, 15 NWLR, Okotiebo versus Manager, 2004, LPLR, and No BK versus FRN 2021. The words employed in section 33, 35, and 153 of the Electoral Act 2010 as amended, which I have reproduced above, are clear, plain, and unambiguous. Effect must be therefore be given to the literal, ordinary, and plain meaning of the words. More so, when doing so will not lead to any absurdity. By section 33, a political party shall be allowed to change or substitute its candidate whose name has been submitted to the appellant where such a candidate dies or withdraws his candidacy. From the attachments to the letter of substitution, the third respondent withdrew his candidature for the first respondent. So the first respondent had the legal right under section 33 to change or substitute him. End of quote. Now, okay, also see Bola Rumi versus PDP and others, 2019. LPLR, Usman and another versus Machido and another, 2009. Inime versus INEC and others, 2013. PDP and another versus Silva and others, 2012 LPLR. The purpose of the above decisions of the Supreme Court is that it is only a notice of withdrawal signed by the plaintiff and delivered to the first defendant in person that will extinguish his candidature to warrant conducting a rerun election. That there can be no rerun election where there was no valid withdrawal. Applying statutory law and case law to the facts of this case, it is not in doubt, therefore, that the plaintiff contested and won the primary election of the first defendant for Imo Federal Constituency of Imo State on 8th July 2022. The point of divergence is the contention by the first defendant that the plaintiff has withdrawn his candidacy, to which the plaintiff deposed that he had no cause or reason whatsoever to relinquish, withdraw, or sell his ticket for any sum, and maintains that at no time did he inform or indicate to Mr. Ahanotu or any officer or official of the first defendant the plaintiff's intention to withdraw his candidacy for the Imo North senatorial seat in the forthcoming election, that he has never thought of, contemplated, intended, or indeed planned to withdraw his candidature, let alone communicating same to the said Mr. Ahanotu or anyone else, that in the two previous times he contested the Imo North senatorial seat under the first defendant, and would have no cause or reason to do so now when his chances of winning the election is very bright as a result of the entrance of Mr. Peter Obi into the party, which has energized and popularized the first defendant, and that he never told Mr. Ahanotu or any official of the first defendant, whether on 8th July 2022 or at any other time, that if Mr. Ararume emerges, the first defendant should pay him the sum of 500 million naira for the voluntary withdrawal of his candidacy. The plaintiff deposed that it will be unconscionable and foolish for him to have voluntarily withdrawn his candidacy, submit a letter of withdrawal to the first defendant, and then turn around to be begging for the payment of the sum of 500 million naira for his purported voluntary withdrawal, as alleged, that the plaintiff could not have demanded for the sum of 500 million naira or any other sum from the first defendant after he had purportedly voluntarily withdrawn his candidature, as the first defendant owed him no other obligation or commitment to warrant it to pay him such huge sum of money, and that he had any intention to make money with his ticket from the first defendant or anyone else. He will have negotiated and agreed on the compromise sum and received same before he prepare and tender the withdrawal letter to pave way for the first defendant to organize another primary election in order to produce another candidate. The plaintiff is vehemently denying the above, contending that he neither relinquished his candidacy nor requested for reimbursement from the first defendant, that he did not write any letter of withdrawal,
May I please, my lord,
Okay.
you are muted, my lord.
Hello? Can you,
Yes, my
Council,
lord.
can you hear me now?
Yes, my lord.
Was I muted for long?
Your lordship was muted for a while.
Okay, I was not aware. I was maybe saying the plaintiff is vehemently denying the above contending that he neither relinquished his candidacy nor requested for reimbursement from the first defendant, that he did not write any letter of withdrawal and could not have signed any letter of withdrawal in the presence of Mr. Aha Notu and the purported commissioner for oaths, and that if he wrote a letter to withdraw his candidature, he will sign same and submit to the national chairman of the first defendant, that he does not need to be taken like a child by Mr. Aha Notu to sign a personal letter before him and an alleged commissioner for oaths, and that the High Court of the Federal Capital Territory, Abuja, where Mr. Aha Notu claimed he took the plaintiff to sign the alleged letter of withdrawal, has been shown by Exhibit R not to exist. The plaintiff deposed that he agrees with the deposition in paragraph 11J of the first defendant counter affidavit only to the extent that this honorable court should compare his signature on the form EC9 attached by the first defendant to his counter affidavit as Exhibit LP13 and plaintiff's Exhibit H1, H2, H3, and H4 with the signature on the documents he attached as Exhibit C, which is the purported letter of withdrawal, and that in his further affidavit before this court, he has requested this honorable court to compare his signature on Exhibit H1 to 4 with the signature on Exhibit G and see that the two signatures are not similar, and that by simple comparison of the signatures on Exhibits H1 and LP3, which is similar, consistent, and regular with the signature on Exhibit G, will show that the plaintiff did not sign Exhibit G as alleged. This honorable court requests to resolve this issue pursuant to Section 122 Evidence Act 2011, judicially having taken notice of its record compared signature of the plaintiff on Form EC9 attached by the first defendant to his counter affidavit as Exhibit LP13 and plaintiff exhibits H1, H2, H3, and H4 with the signature on the document he attached as Exhibit G, which is the purported letter of withdrawal. This honorable court observed that the signatures differ. The court also compared the plaintiff's signature on Exhibits H1 to 4 with the signature on Exhibit G and observed that the signatures are not similar, and that by a simple comparison of the signatures on Exhibit H1 and LP13, which is similar, consistent, and regular with the signature on Exhibit G, shows that the plaintiff did not sign Exhibit D as alleged. Comparing those signatures with the signature allegedly presented by the plaintiff as his own signature, with the signature on Exhibit G annexed to the first defendant's counter affidavit, as well as Exhibits H1 to 4 attached to the state plaintiff's exhibits, the plaintiffs deny an Exhibit G, which the plaintiff denies signing. The signatures on the aforementioned exhibit are next to the first defendant's counter affidavit are significantly dissimilar. Maybe they were all made in an attempt to imitate the signature of the plaintiff. This honorable court finds that the signatures upon comparison are materially different, I so hold. The contention of the defendants that the plaintiff on his own volition withdrew from the context and went on to which the plaintiff deposed that after the defendant failed to get him to trade or sell his ticket for money, it wrote a letter to the second defendant that the plaintiff had withdrawn his candidature and sought for a date to conduct another primary election to produce a candidate for the Imo North Senatorial Zone, and that on the 13th July 2022, when the plaintiff became aware of Exhibit D, that's first defendant's letter to the second defendant alleging that the plaintiff had withdrawn his candidacy and the plot of the first defendant
My lord is
My lord,
muted.
Counsel,
Lord. Yes, my lord.
can you hear me?
We can hear you now, my lord.
Okay, I'm so sorry. I don't know. It seems I must have mistakenly pressed something. Okay. That on the 13th July 2022, when the plaintiff became aware of Exhibit D, that is the first defendant's letter to the second defendant alleging that the plaintiff had withdrawn his candidacy, and the first defendant's plot to take away his ticket and give same to another person, the plaintiff quickly instructed his counsel to write to the second defendant, informing it of that he did not write any letter to the first defendant withdrawing his candidacy and has no intention to do so, and that any letter purporting to withdraw his candidature did not emanate from him and should be investigated. The plaintiff deposed that the first defendant wrote a petition to the Nigerian police to investigate the assertion in plaintiff's letter to the second defendant that he did not withdraw his candidature. And the first defendant started the personnel of the Nigerian police to harass, intimidate, and silence the plaintiff from asserting and insisting that he did not withdraw his candidature of the Imo North Senatorial Zone seat, and that when the Nigerian police intensified efforts to arrest and detain him, thereby incapacitating him from pursuing remedies available to him against the acts of the first defendant, the plaintiff approached the High Court of the Federal Capital Territory, Abuja, by bringing an action against the first defendant and the Nigerian police. That the court gave judgment in plaintiff's favor and found that the first defendant was using the police to harass, intimidate, and silence him from pursuing his rights. And the court found that the Nigerian police had no business investigating the petition of the defendant, and the act of the first defendant and the police was a breach of the plaintiff's fundamental right, and neither the first defendant nor the Nigerian police appealed against the judgment of the court. The plaintiff stated that his claim before the court, which he had maintained all through, is that he did not withdraw his candidature and that he did not write or submit Exhibit G or any such letter to the first defendant, and Exhibit J and R are very relevant with respect to Exhibit G, and that he knows as a fact that it is the first defendant who forwarded Exhibit G to the second defendant that can explain how it procured it. The plaintiff stated that the real issue in contention in this suit emanated from Exhibit D attached to his affidavit in support of the originating summons written by the first defendant to the second defendant, alleging that the plaintiff had voluntarily withdrawn his candidacy as the senatorial candidate of the first defendant for the Imo North senatorial seat in the 2023 general election via a purported letter of voluntary withdrawal, and that is support submitted to the first defendant. That when the plaintiff got information regarding the conduct of the first defendant and the facts of Exhibit D, he quickly wrote a letter dated 13th July 2022. That's Exhibit E to the second defendant, disclaiming any purported letter of withdrawal. And affidavits in support there are allegedly submitted by him to the first defendants. And to forestall any detrimental action from the second defendant to Exhibit E, to forestall any detrimental action to his candidacy that may be taken by the second defendant arising from the first defendant, Exhibit D, the plaintiff instituted this suit to seek the court's intervention and protection, and that at the time he instituted the suit on 14th July 2022, he had not seen or read either the alleged letter of voluntary withdrawal purportedly written by him or the alleged affidavit in support of the said letter of withdrawal, as none of the defendants availed him with a copy. Until the 14th of September 2022, when the first defendant served his counsel its counter affidavit to a motion for injunction dated 14th July, wherein it attached the purported letter of voluntary withdrawal as Exhibit LP1. That upon the receipt of the first defendant counter affidavit alleging that the plaintiff is at the registry of the High Court of the Federal High Court Territory, Karu, Abuja, to sign a letter of withdrawal, the plaintiff instructed his client and his counsel to write to the Chief Registrar of the High Court of the Federal Capital Territory, Abuja, to formally verify if there's any division of the High Court of the Federal Capital Territory, Karu, Abuja, which counsel did, and counsel's letter is attached and marked as Exhibit Q. The Chief Registrar of the High Court of the Federal Capital Territory, Abuja, replied Exhibit Q with a letter dated 7th October 2022, and same attached and marked as Exhibit R. That in Exhibit R, the Chief Registrar of the High Court of the Federal Capital Territory specifically stated that his or court does not have a division in Karu. As alleged, the Chief Registrar of the High Court of the Federal Capital Territory, Abuja, is a high-ranking officer of the head of administration of that court. That Exhibit R is an eloquent fact that no division of court of the High Court of the Federal Capital Territory, Abuja, Karu, Abuja, exists or is located in Abuja. Therefore, the plaintiff stated that he knows that the fact he could not have gone to the registry of a non-existent court, either on his own or led by Mr. Ahanotu as alleged, and could not have signed the purported Exhibit LP1, Exhibit G, in the presence of Mr. Ahanotu or Mr. Gashua before a non-existent commissioner of oaths in a non-existent court. Now, this honorable court holds that from the above depositions prove that the substitution of the candidature of the plaintiff was done wrongfully. A document in law speaks for itself, and it is the evidence presented by parties in the manner presented by the parties that the court will look at in deciding the life issues before it. See Adisa versus the state 1999, 1 NWLR. The duty of proving the plaintiff was lawfully substituted lies squarely on the first defendant to establish with cogent, convincing, and credible evidence that there was compliance with Section 31 of the Electoral Act in substituting the plaintiff. In this case, where the plaintiff is denying withdrawing his candidature in proof of his case, the plaintiff has laid credible evidence through his affidavits in support of the originating motions by the documentary and by the documentary evidence marks, the evidence led by the plaintiff are of great probative value, and we are quite useful in resolving the issues before this honorable court. Especially exhibits J and R were made by the Chief Registrar of the High Court of the Federal Capital Territory, Abuja, a very high-ranking officer, and the administrative head of that court. This honorable court holds that exhibit J and R holds the key to the unlocking the mystery behind exhibit G, as well as providing great basis to assess the credibility of the evidence on both sides. Exhibit J and R are very vital in that they render exhibit G, that is the defendant's evidence, that is the defendant's exhibit LP1, the purported letter of withdrawal, questionable, and the entire evidence led by the first defendant, particularly the counter affidavit of Mr. Kennedy Ahanato, the Deputy National Secretary of the first defendant, and that of one Mohammed Gashua, a staff of the High Court, unbelievable, and I so hold. The condition of valid withdrawal of death of a candidate was not fulfilled here, and the action of the first defendant in conducting another primary election has no basis in law. Notwithstanding the fact that the second defendant monitored the fresh primary election, the said primary is a nullity, and the outcome of the primary is void and lacks judicial legal backing, I so hold. In the final analysis, the plaintiff has succeeded in has successfully proved his case. Consequently, the plaintiff is hereby declared the validly nominated candidate of the first defendant for the election, having emerged winner of the earlier conducted primary election. The plaintiff is hereby declared the validly nominated candidate of the first defendant for the election, having emerged winner of the earlier conducted primary election. Accordingly, this honorable court holds that the plaintiff remains the validly nominated candidate of the first defendant for the Imo State Federal Constituency, Imo North Federal Constituency, Senatorial District Constituency of Imo State in the forthcoming 2023 general election. In the same vein, the primary election conducted having no basis on the 13th July, having no basis in law, is hereby declared null, void, and of no effect together with its outcome. The first defendant is hereby ordered to present the name and details of the plaintiff to the second defendant as its rightful candidate, judgment given in favor of the plaintiff. This is my decision.
We are very grateful to my Lord. We appreciate my love industry and time put into this judgment. And we wish my Lord a very prosperous new year. Thank you, my Lord.
Thank you so much, counsel.
On behalf of the first defendants, we thank your lordship for the judgment.
Okay. Thank you, counsel. You don't have any other case for the day? Okay, in that case, thank you so much, counsel. Thank you, participants, although I'll have to register my, I'll say, annoyance for the disruption during the delivery of this judgment. When you join by Zoom, you're supposed to mute your gadgets and just listen as if you are in a traditional court sitting. But most of the participants who happens to join have been disrupting the court's proceedings. I hope you will all take note in case of future occurrence. Meanwhile, thank you so much, Mr. Fatai, for assisting the court in these virtual proceedings. Thank you so much, staff of the Federal High Court as well.
Thank you,
Have
madam.
a pleasant day. Thank you so much. Bye-bye.
Thank you, madam.
Because